right, hi everybody. Thank you again so much for being here. We're really excited to share a little bit of information on HOAs and condos with you today. I am not Beth Mulcahy, who was supposed to be doing this presentation today, but I am from Beth Mulcahy's office. Again, my name is Haidyn DiLorenzo. I'm an associate attorney with Mulcahy Law Firm. I've been with the law firm for about a year and a half now. I'm also an Arizona native. I was born and raised in Scottsdale, so just keeping this area, going strong with the good HOAs and associations we've got going on. That's very important to me, so thank you all for your interest and for your support with this. Okay, so today's presentation is going to cover quite a few topics about HOA and condo law. So we've got some of the biggest things that you're going to need to know, and that's going to be the fiduciary duties of board members, Arizona open meeting law, annual meetings, the board removal process. We'll talk a little bit about the 2022 legislation and the new laws that have been passed that will affect HOAs and condos. And then a little bit on signs, flags, and solar panels, records requests in HOAs, fines, associations, financial responsibilities, a little bit about the Fair Housing Act and how that impacts HOAs, and then we'll talk a little bit about rental properties as well. Awesome. Okay. So starting with duties and responsibilities of board members. So when you're on the board in an HOA, there's a few things that you're responsible for doing. And we have a pretty long list of just a few of them. So number one is to play a participatory role, attending board meetings, arriving on time, just generally knowing the association's documents, researching some board issues and being ready to discuss those issues. So that's number one. Also just to read, understand, and follow the governing documents. Now, as some of you might know, these governing documents can be very lengthy. They can be a little tedious to get through, but we definitely recommend just having taking 15 minutes, read through them, get a general understanding at least, and that will be a good start on your way to understanding your governing documents. Next would be adhering to the fiduciary duties to the association. Placing the interests of the association above their own. So this is going to be having to do with fairness and impartiality, acting on the board. Overseeing and treating the association services and facilities as a business. So vendors, companies that the association is working with. And then overseeing the management company, if there is one, which in turn will oversee things like the banking budgets, insurance, utilities, etc. And then another duty of a board member is to give notice and hold regular board meetings and annual meetings. So this is according to Arizona law. Arizona open meeting law in particular requires that these meetings be open to the membership. And then following that, just following and enforcing the rules and regulations of the association. So these will be governed mostly by the association's CC&Rs and bylaws. And along with that, collecting assessments fairly and consistently. Okay, we've got a few more duties and responsibilities of board members. This first one is giving reasonable notice of CC&R violations with an opportunity to be heard before levying reasonable fines. So anytime that there's a violation in the community and notice is being given, it should be in writing and it should be providing an opportunity for that homeowner to be heard and to reply on that. And then moving on to complying with owners' requests to inspect and review records of the association, which is, again, an Arizona law requirement. I think we have a little bit more on records requests later as well. Additionally, providing open communication to the membership, such as things like a newsletter, website, ways to stay in contact with your community. And then preparing an annual budget and adhering to the budget. This is a requirement of a board member as well. Having a reserve study completed and adequate funds to fund the reserve if the board chooses or if required by the documents. And then having financial records audited or reviewed, or a compilation done yearly as stated in the governing documents and pursuant to Arizona law. Okay, I think this is our last page of duties and responsibilities. You sure have a lot to do, don't you? Following that is protecting the association and board by having the required insurances in adequate amounts. So these are something that you will also find in your governing documents. Hiring professionals when necessary and following their professional advice. Maintaining active corporate status by paying the annual renewal fee and filing the required annual report with the Arizona Corporation Commission. And then preparing for the annual meeting, notifying the membership and planning for mail-in and absentee ballots pursuant to Arizona law. Finding potential new officers and establishing a voting process in a fair and open manner. Having an approachable business-like manner as a board member. And finally, filing state and federal taxes annually, and if a planned community, paying property taxes in a timely manner. Okay, so we're starting with Arizona open meeting law, which is always a fun topic. Lots to talk about on this one. So as an HOA or condo in Arizona, all meetings of an association, board of directors, and also regularly scheduled committees, they're required to be open to all association members or their representatives who have been designated in writing and held in Arizona. Members or their designated representatives are allowed to attend and speak at an appropriate time during the deliberations and proceeding of all open meetings of the association, board of directors, and committees. Now, that is something that comes up a lot, what is a reasonable time? So a lot of boards will designate time at the beginning or end of their meetings for homeowner forum, time for the homeowners to let their concerns be known. And this can be a short amount of time. It doesn't have to be an extensive amount of time. It's just an opportunity for these owners to be heard and understood. Yes, and so the only time that this is a requirement is going to be prior to, it's going to be at an open board meeting prior to the board taking any formal action. So if the board's about to take formal action on an item and an owner wants to speak on that is a time when it's going to be required of them. Okay, a little more on Arizona open meeting law. This is going to be discussing executive sessions and when the board can go into executive session. Particularly, there are 5 instances where a board can have a closed portion of a meeting. And this is going to be, number 1, when they're discussing legal advice from an attorney for the board of the association. Number 2, when the board is discussing pending or contemplated litigation, so any court cases or litigation that is ongoing or contemplated. Anytime that the personal, health, and financial information about an individual member of the association is being discussed, in addition to individual employees of the association or individual employees of a contractor for the association. Another time that the board may close a portion of the meeting is when matters relating to job performance, compensation, health records, or specific complaints against an individual employee of the association, or an individual employee of the contractor of the association who works under the direction of the association is being discussed. So that's another instance where a board meeting may be closed. And finally, discussion of a unit owner's appeal of any violation or penalty imposed by the association. And this is with the caveat that if that affected owner who is in violation and is requesting an appeal requests that the meeting be held in open session, then the board is required to hold that appeal during open session. And then moving on with more Arizona open meeting law information, prior to entering any executive session based on one of those 5 reasons previously discussed, the board is required to identify the section, which was just mentioned in 1 through 5, that authorize the board to close the meeting. So this should be verbally announced and also placed on the agenda so that owners are aware, and also included in the meeting minutes. So a couple of things we run into sometimes with our HOA boards is that they'll go into an executive session sometimes, and they will intend to talk about one of those 5 exceptions that allow them to go into executive session. But a lot of times what will happen is the board will end up getting off course and discussing other things that weren't one of those exceptions. This is where we want to be careful, as that in that case is veering into the realm of potentially violating open meeting law. So this is something to be aware of. Another thing that will kind of throw boards off sometimes is hiring or firing of vendors. In our firm's opinion, that should also be done in open session. That is not one of the exceptions to allow for executive session. Okay, additionally, the agenda must be available to all owners attending any meeting. And then there's also the topic of emergency meetings. And an emergency meeting may be called to discuss only emergency matters, but the reasons for the emergency meeting must be included in the meeting minutes, and the meeting minutes must be read and approved at the next regular board meeting. So what is an emergency, you might be asking? Typically this standard is pretty high. So it's very rare that, that a board will have need for an emergency meeting. We highly recommend that most topics to be discussed that weren't previously cited as an exception should be discussed according to Arizona open meeting law. All right, this is continuing on Arizona open meeting law. It's a very big topic with HOAs, and this is the question of informal board meetings. Do we still have to notice an informal board meeting? The answer to that is going to be yes. Our firm's opinion is that we should be noticing all board meetings, whether formal or informal, and just allowing the association, or the homeowners within the association to be aware of the meeting, the date, place, and time of the meeting, and the topics to be discussed. A quorum of the board may meet by telephone conference if there's a speakerphone available in the meeting room that allows board members and unit or lot owners to hear all parties who are speaking during the meeting. Any quorum of the board that meets informally to discuss association business, including workshops, must comply with open meeting and notice provisions, regardless of whether any action is taken. Interpretation of the open meeting statute is to be construed in favor of open meetings. So again, where possible and at every opportunity, I think you should err on the side of complying with Arizona open meeting law, and that will just keep a lot of problems away. Okay, and then homeowners are permitted to tape and or video record open board meetings, subject to reasonable rules and regulations adopted by the board. So that is also something to keep in mind at these meetings. And furthermore, as a suggestion, plan to go into executive session prior to or after the meeting so that members do not have to wait. So this is just a recommendation to make things go a little more smoothly, is just to do the executive session either before or after the rest of the meeting so that members are not waiting for that to be done. In addition, explain to the members that under Arizona law, the board is entitled to meet in executive session and explain why you are going into executive session. So that will be one of the reasons previously listed. All right, so this is moving on to annual meetings. So as some of you might know, under Arizona law, an association must conduct an annual meeting of its membership at least once a year. So conducting a successful annual meeting requires knowledge of the association's documents, planning, organization. It's definitely a big event for an HOA. So we highly recommend that you go ahead and check out our cheat sheet that we have on annual meetings for HOAs and condos. This is going to give you just tons of information and suggestions from our firm on how to successfully hold an annual meeting as required under Arizona law. Okay, next we're moving on to the board removal process. So this procedure does not apply to board members appointed by the developer and supersedes any other provisions in the association's documents pertaining to removal of board members. So a lot of times what we see is an HOA or a board will have in their bylaws a procedure for board removal. This basically, you can throw that out the window. This Arizona law will supersede that. So this is the process for board removal. One, a petition for the removal of director. So the requirements of that. Let's see. So according to Arizona law, associations with 1,000 or fewer members, a petition must be presented to the board for removal of a director that is signed by the number of persons who are eligible to cast at least 25% of the votes in the association, or 100 votes in the association, whichever is less. And then B, for associations with over 1,000 members, a petition must be presented to the board for removal of a director that is signed by the number of persons who are eligible to cast at least 10% of the votes in the association, or 1,000 votes in the association, whichever is less. The second step for removal is going to be a special meeting. The special meeting must be called, noticed, and held within 30 days after receipt of the petition for removal. One thing that we do recommend if you do receive one of these petitions for removal and you're on the board, we highly recommend getting in contact with your legal counsel as quickly as possible, as there is this 30-day window, and there's much to be done between that time and the time that the special meeting is held. So we highly recommend getting in touch with counsel if that does occur. Okay, and then number 3 is going to be a quorum. So a quorum for the removal meeting purpose is met if the number of owners who are eligible to vote at the time the person attends the meeting are equal to at least 20% of the votes, or 1,000 votes, whichever is less, are present at the meeting in person or as otherwise permitted by law. So this will also supersede any quorum requirements that you have in your documents. So for purposes of the removal process, this is the quorum that you're going to want to follow on that. Okay, number 4, percentage required to remove a director. A member of the board can be removed from office with or without cause by a majority vote of the members eligible to vote who are voting on the matter at a meeting of the members called for the removal purpose, so long as a quorum is present. And then 5, retention of documents. The board must retain documents related to proposed removal for at least 1 year after the special meeting and shall permit inspection of these records by members. So that is going to be one of the records that we discuss in our records request portion. So that's something to be aware of as well. And then here's the good news, only 1 removal attempt per term. So if you do receive one of those removal petitions, as long as it happens once, that's the only time that it can happen for the rest of your term. So good news. Okay, and then on removal of at least 1 but fewer than the majority of the board members at a special meeting called pursuant to this subsection, the vacancies shall be filled as provided in the association's documents. So at this point, the association's documents will come and fill in for the process of filling the vacancies. On removal of a majority of the members of the board of directors at a special meeting of the membership called pursuant to this subsection, or if the association documents do not provide a method for filling in board vacancies, the association shall hold an election for the replacement of the removed directors at a separate meeting of the members of the association that is held not later than 30 days after the meeting at which the members of the board of directors were removed. So a member of the board of directors who is removed pursuant to this subsection is not eligible to serve on the board of directors again until after the expiration of the removed board member's term of office, unless the association's documents specify differently. Okay, so we're moving on to some interesting topics. This is going to be the new 2022 legislation that is going to be affecting HOA and condos in Arizona. So the first one of these is going to be HB 2131, and this is regarding artificial grass ban prohibited. So in other words, this is making it boards are not allowed to prohibit artificial grass within their associations. This is subject to a few exceptions, more of which I think can be found on our cheat sheet on the matter. I believe we had a cheat sheet for you guys on the 2022 legislation. The gray one, thank you. Yes, so all the details can be found on there as well. In addition to the next condo laws, HOA and condo laws. The next one's going to be HB 2158, and this is going to relate to political and community activity. And that basically is just going to clarify a little bit of information on those terms and what that's going to mean for HOAs and condos. And then we've got HB 2010, that's going to be dealing with first responder flags. So as you might know, there are certain flags that HOAs and condos cannot prohibit their owners from placing on their lot or unit. And this includes things like the American flag, the POW flag, and now, in addition to the ones listed in the past, there is also first responder flags, which has been added. We've also got some more information on condominium termination, which doesn't happen very often, but it is some new information in HB 2275. And finally, SB 1168, which will discuss vacation and short-term rentals and enforcement of those. So that one's going to be very interesting to a lot of HOAs. I know that's a very hot topic right now. So that's definitely something worth checking out on our cheat sheet as well. Okay, so kind of going off of that topic a little bit, another big topic that comes up in HOAs frequently is going to be these three topics on screen. We've got signs, flags, and solar panels. So the deal with signs is similar to the laws on flags, which is there are certain signs that, according to Arizona law, an HOA board cannot prohibit. This is going to be mostly related to political signs. There are protections in law to protect an owner's ability to have political signs on their property, in addition to some others which are stated in the statute. So some of these are going to be like one for sale sign, one for rent sign. So there are certain signs that cannot be prohibited. In that same vein, there are also some flags that can't be prohibited. We talked a little bit about that. And there's a more full list, I believe, on our cheat sheet for that as well. And then with regard to solar panels, which is another hot topic in HOAs right now, according to Arizona law, you should know that an HOA cannot effectively prohibit solar panels. So what is effectively prohibiting? Honestly, it's very broad. The courts tend to find that restrictions on solar panels tend towards effectively prohibiting them. So if you have an owner who is asking about solar panel installation and you aren't sure, we would recommend seeking advice from your attorney or legal counsel on that matter. Moving forward, okay, another one of my favorite topics. We've got records requests by owners. So, according to Arizona law, all financial and other records of the association shall be made reasonably available for examination by any member or any person designated by the member in writing as the member's representative. Books and records kept by or on behalf of the association and the board may be withheld from disclosure to the extent that the portion withheld relates to any of the following. So we've got 1, privileged communication between an attorney for the association and the association. So anytime that the association is interacting with its attorney and it's privileged communication, this does not have to be disclosed to owners who are seeking a records request. Number two, anything regarding pending litigation. So if the association is involved in any pending litigation, whether this be a foreclosure suit, a suit to recover damages, anything like that, that does not have to be disclosed in a records request either. The third one is going to be meeting minutes or other records of a session of an executive session board meeting. So if the board can close off that portion of the meeting, then the minutes do not have to be given to the owners on a records request. And four, any personal health or financial records of an individual member of the association, an individual employee of the association, or an individual employee of a contractor for the association. So these are four of the things that do not have to be disclosed in a records request. We've got one more, which is going to be records relating to the job performance of, compensation of, health records of, or specific complaints against an individual employee of the association or an individual employee of a contractor of the association who works under direction of the association. So legislation enacted in 2006 entitles owners to see association books and records pertaining to contemplated litigation. So in the event that litigation hasn't been initiated yet, and the owners want to see records of that, they are entitled to see that information. And then, okay, so this is kind of going off of that. If a owner is requesting records from the association can't charge the member for making books and records available. However, they can charge 15 cents per page for copies of records. So the association will have 10 business days to submit, from the submission of a written request by an owner to submit these records with, of course, the exception of the records that I have previously mentioned. A lot of times, this is a very prominent topic for HOAs these days. We definitely get a lot of records requests at our office coming through from owners who are requesting it of their HOA. Essentially, most records should be disclosed if requested in writing. At the same time, a lot of times we have owners who are habitually and regularly requesting records to the point where it almost becomes a matter of harassment of the board or management company, and there's no way that they can possibly get the extent of records that they're requesting in 10 days. If that's the case, first of all, use your association's attorney as a resource. They're definitely well-equipped to handle those kinds of situations. What our firm will do a lot of times if it's a very voluminous request is that we'll immediately contact the owner, let them know that due to the volume of the request, it'll take a little bit more time than the 10 days. And then also, we do recommend letting them know that they will be charged per page. So if it's just an absurd amount of records that are being requested, sometimes letting them know that the charge per page will be in effect is enough to at least condense the scope of the records requested. So that can be helpful. Okay, moving on to fines. An association can impose reasonable fines against owners for violations of the CC&R's bylaws and other documents of the association after notice and an opportunity to be heard. So you might ask what constitutes notice and an opportunity to be heard. So we do recommend providing any notice of a violation in writing, and an opportunity to be heard can be the opportunity to be heard in person, via an appeal, the opportunity for them to submit a written reply or even an email reply. So that will kind of cover that requirement. So the fine must be set up correctly with 2 letters. So notice with instructions on the opportunity to be heard, and then the wait time period, and then issue a letter with or without a fine. So the first letter, no fine. Second letter, yes or no on a fine. Okay, so according to Arizona law, any fines with regard to violations of the association's documents must be reasonable. Now, that leads to a good question. What is a reasonable fine? So this will probably look pretty common sense to most people, probably charging $1,000 in fines for somebody failing to trim their tree, for example. Probably not a reasonable fine. As opposed to $50, definitely getting more towards reasonable there. And then, as already discussed, what is considered notice and opportunity to be heard? If you have any further questions on that, please feel free to let me know. A big topic with associations is enforcement of these fines, of payment of the fines. So there are a couple of things that you can do if an owner is not paying their fines. The first is going to be filing a lawsuit against the owner. This is something that the board is able to do. Again, this is going to kind of depend on the circumstances. Obviously, we're probably not going to file a lawsuit for failure to pay a $50 fine. Probably wouldn't be worth it in the end, but again, fully up to the board. Obtaining a judgment against the owner. So that's along with filing the lawsuit, and then recording the judgment with the county recorder's office. After a judgment is recorded, the association will have a judgment lien against the owner for the fines. So going off of that, proceeding with collection of the judgment through traditional collection means such as a bank or wage garnishment is at your disposal. That's an option for you. And then associations, just as an FYI, associations no longer have the right to record a notice of lien for unpaid fines. So this is something that used to be an option, but is no longer an option pursuant to Arizona law. So the options previously discussed are probably going to be your best bet there. All right, actually, did we get all the way through it? Let's see. Fines are used to get compliance. As I said, it's a good tool to have in your back pocket just in case it's really difficult to get an owner to comply with the documents. Again, self-help was mentioned earlier. That is another thing that you might want to check your documents for. That's something that is always a good thing to check for as well if you're looking to get compliance with your association's documents and you just can't get an owner to mow the lawn or clean up the property or anything like that. Some associations will have provisions in their documents that will allow the board or their management company to hire someone to go in and clean up the property and then bill that expense of doing so back to the owner themselves. So that's something to look out for as well. Alrighty, moving right along, we've got the association's financial responsibilities. So there should have been only two. I apologize for the typo there, but the two of these financial responsibilities are going to be filing the annual report with the Arizona Corporation Commission and filing state and federal taxes and conducting audits and reviews or compilations annually. So, right, the filing of the annual report with the Arizona Corporation Commission, this is going to be a state requirement. So this is something that you should be doing every year with your association. And then again, state and federal taxes, and then conducting an audit. And this, if your association documents require it, these kinds of reviews may require it to be done by a CPA. Otherwise, this can be done by committee or by a board member, kind of more informally. So that's something to know and to look out for in your documents as well. All right, so this topic is going to be the Federal Fair Housing Act. This is something that we're going to want to pay attention to in HOAs and condos, as this can pose some problems if not handled correctly. So the Federal Fair Housing Act says that associations cannot discriminate based upon a number of factors, these being race or color, religion, sex, which includes sexual harassment, national origin, familial status, or disability. So it's only these 6, I believe, that are that cannot be discriminated on the basis of those, based on the Federal Fair Housing Act. So this is a federal law. It's very important to make sure that we are abiding by those. And here's a little bit more information on that as well. We also do have a cheat sheet on this. This is going to be our federal laws cheat sheet. It's got a lot of extra really good information for you. But kind of just to define this a little bit better, we've got disability. This is going to be described as an individual with a disability is defined as a person who has a physical or mental impairment that substantially limits one or more major life activities, a person who has a history or record of such impairment, or a person who is perceived by others as having such impairment. So this is a very broad category. Usually, if somebody is claiming a disability, they will fall under this category, and we will not be able to, basically, the Fair Housing Act prohibits any discrimination based on any disability. In terms of discrimination, what it means, that's going to be treatment of an individual based on their membership in a certain group or category, those 6 that I previously mentioned. It involves excluding or restricting a member of one group from opportunities that are available to other groups. So this happens when the community association fails to allow an accommodation or reasonable modification to the community's common elements. So some examples of a reasonable accommodation or some further clarification on what that means. A reasonable accommodation is going to be alteration to or variance of the association's CC&Rs, policies, and services to provide a disabled person equal use and enjoyment of his or her home. So an example of this would be an association that has a no pet policy, allowing an owner that maybe has anxiety or has PTSD or some kind of disability like this to have a pet despite that policy. So that's one reasonable accommodation. Usually the pets that are allowed due to disability as a reasonable accommodation still need to be in compliance with other rules and regulations regarding pets within the association. So for example, if the association has a rule stating that all dogs must be walked on leashes in common areas, just because a dog is an accommodation does not, so say that they have a second dog and they're only supposed to have one, but as an accommodation they have a second dog. This dog still needs to be walked on a leash like all other dogs in the association would be. So usually it has to kind of comply with those same standards. And then the difference basically between a reasonable accommodation and a reasonable modification. An accommodation is going to be allowing something that would not otherwise be allowable by the community documents. A modification, by comparison, is going to be an alteration to the building or common elements or limited common elements of the association. That will afford the ability for that individual to enjoy and use the property in the same manner as others, or in a comparable manner as others within the community. So the fair housing laws require the association to allow modification, sorry for that typo, to the common elements so the disabled individual can use the facilities. All right, another question which comes up pretty often is going to be the question of group homes. So a group home is a group of unrelated disabled individuals living together in a dwelling. That is the definition. And then, so basically in this situation you would separate what can be prohibited and what cannot be prohibited. What can be prohibited in terms of a group home is going to be current addicts, current substance abusers, current alcoholics, criminals, those with bad credit, and sex offenders. So this is not considered a disability under FHA laws. However, to distinguish from that, recovering addicts, recovering alcoholics, things of this nature, the association will not be able to prohibit these kinds of group homes in their association according to the FHA. So that is a distinction to draw. And then, again, the association has a right to enforce the same rules and restrictions asked of all residents. So if there is this type of home allowed in the community, every member of that home must be abiding by the association's rules and regulations and restrictions, just as any other homeowner would be. All right. And then a group home owner will have to request any variance or accommodation of the governing documents and show that the variance is directly connected to diminishing the effects of the disability or residence in the home. So it'll just have to be directly tied to the disability. All right, okay, so a little more information on assistance animals. So we've got basically, as we were discussing, the reasonable accommodation. This is one of the biggest ones we're going to see in HOAs and condos, especially recently. This has really taken off. So a couple of factors have to be met for this to be considered a reasonable accommodation for a disability. First, the person requesting the accommodation must have a disability. Second, the assistance animal must serve a function related to that disability. So say that the owner's disability is anxiety, their pet that they are requesting as an accommodation helps to reduce that kind of anxiety, directly correlated. And then the request must be reasonable. So maybe this is where we get into the question about the mini horse. Is a mini horse reasonable in a small condo? Maybe not. So this is the kind of questions that we have to ask. But typically, we do find that requests for a second dog or a dog, if they're not allowed in the association, typically we do find that those are a reasonable accommodation, and the courts tend to agree with that. However, if this is granted and the association grants the reasonable accommodation, allows that pet to be owned by the owner, there are a couple of things that the association can require of that resident. Number one is providing proof of the disability from a physician. So this is related to the first factor that a person must have a disability. They are allowed to require proof. Two is, with the exception that if the disability is readily apparent and obvious, they cannot ask for further evidence of the disability. So that's something to be aware of as well. The association can provide or can ask them to provide a physician's statement that the animal is medically necessary, and they can require that the pets as an accommodation follow all of the same policies required under their documents as well. Okay, so moving on to rental properties, which is a very hot topic in HOAs and condos these days, especially when it comes to short-term rentals, which is really a topic of concern for a lot of HOAs. So when it comes to rental properties, it's very important to remember that the CC&Rs are a contract between the association and all the owners within the association. So when it comes to rental properties, according to Arizona law, owners have the right to rent their property in a planned community or a condominium unless rentals are prohibited in the CC&Rs. So this is going to have to be explicit. The CC&Rs will have to explicitly say no rentals, but if they do say that, then they can be prohibited within the association. And additionally, associations can have rental time restrictions in the declaration. So a 30-day minimum, for example, so that their properties are not being put on Airbnb for 2 days out of the week and having new people in and out of the association at all times. A lot of associations will opt to do this. What can an association require from a landlord regarding a tenant? So there are Arizona laws on this. What they can require is the name and contact information for any adults occupying the unit, the time period of the lease, including the beginning and ending dates of the tenancy, and also a description of the license plate numbers of any tenant vehicles. So this is some information that the association is allowed to request from rental property owners. If the association is an age-restricted community, the owner or owner's agent or the tenant must provide the association with identification, which shows that they're conforming with the minimum age restrictions. And then fees that can be charged for registering. In providing the information about the tenant, the association may charge the owner a fee of no more than $25. The fee may be charged for each new tenant, but cannot be charged if the same tenants renew an existing lease. There's also a $15 late fee if the owner doesn't pay within 15 days after the postmarked request. So that is something to keep in mind as well. Okay, a little bit more on rental properties. Associations are going to be prohibited from requiring any owner to disclose to the association information such as tenant's rental application, so they cannot require that application be disclosed. Credit report, so they can't require that they show a credit report. They can't require a copy of the lease agreement and or rental contract, and they also cannot require any other personal information besides what was already discussed on the previous slide. Okay. And a couple more interesting aspects of the current Arizona laws on rental properties in HOAs. Let's start with the association can't prohibit or otherwise restrict a member from serving on the board based on the members not occupying the property. So even if the owner is not the occupant and they're renting their property, they are still permitted to serve on the board like any other member. An owner may use a crime-free addendum as part of a lease agreement. This section does not prohibit the owner's use of a crime-free addendum. And then we have a little bit more information on this on our blog entitled Crime-Free Lease Addendums. This is also a good opportunity to say that on our firm's website, if you go on mulcahylawfirm.com, there are just tons and tons of free resources available to you where you can find tons more information on any of these topics that might interest you. So I also encourage you to do that if you haven't already. Okay, an important point for rental properties. An association or its manager cannot assess, levy, or charge a fee or fine, or otherwise impose any other requirements on an owner's rental unit that are any different from any owner-occupied unit within the association. So for example, you can't charge a tenant a parking fee if the same fee is not being charged to an owner. So that's something to keep in mind. Landlords must register rental properties. So this is a county requirement. So pursuant to Arizona law, an owner of residential property in Arizona is required to file a notification form with the county where the residential property is located. So it's supposed to have the following information: the name, address, telephone number, street address, and the year the property was built. If you suspect that an owner is not complying with this and the association does not want the rental property to be existing within the association, this is also something that you can take up with the county to kind of help you with that enforcement matter. So that's just an option at your disposal as well. Okay, awesome. And this is going to be some of our solutions for dealing with rental issues. This is, by the way, one of the biggest problems that we see coming to us from our associations that we represent at our firm. Rental issues are really big right now, and so this is definitely something that you might want to be aware of. So one solution to this, if you're having trouble with short-term rentals, which a lot of associations are, one option is to amend the CC&Rs to restrict the short-term rentals. Now, this is going to be a bit of a process. It will need the requisite approval of the membership to amend its CC&Rs. So there will be likely a provision in your CC&Rs that will tell you what the required membership approval percentage is, and you will have to get that percent of approval from the membership in order to amend the CC&Rs. So it can be a bit of a process, but it's definitely worth pursuing if you're having some trouble with short-term rentals. And then we've also got a little bit more information on that in our cheat sheet, which I believe has been provided to you, and that is amending association documents and implementing rental restrictions. So that's a good one to check out if that's an issue that your HOA is facing. And then some further solutions would just be documenting and providing evidence to the landlord if it's tenant issues that you're dealing with. We always recommend keeping a written record, police reports, letters, just keeping that all written down. And then just sometimes it can be as simple as just picking up the phone and calling the landlord, or having your legal counsel or our firm do that for you. We do this all the time. Sometimes it just takes a conversation about the problem for it to be fixed. So it can be as simple as that. And then continuing to find the owner, which is something that we've discussed a little bit previously. It's definitely a good tool to have in your back pocket. And then the best way to get a tenant to comply with the association's documents is, again, to make it hurt in the landlord's pocket. So the landlord will not want their tenant to continue doing what they're doing if it's costing the owner money. So good to know. And then additionally, you can push for eviction. So that is another option. As a last resort, our firm sometimes recommends filing a lawsuit or an ADRE complaint. That's Arizona Department of Real Estate, which does now handle some disputes between HOAs and owners within HOAs. Okay, any other questions?
All right, thanks Haidyn for coming out. Thank you.
Thank you guys so much.